All right. So as people trickle in, again, welcome to the Montana Land Use Planning Act or MLUPA Lunch and Learn webinar. My name is Takami Clark. I'm the Communications and Engagement Manager at the City of Bozeman. I'll be giving a portion of this presentation before handing it over to Chris. And before I introduce him, just wanted to point out we also have Emily Kiley here. So Emily, do you want to say hi real quick?
Hi, everyone. Thanks for coming. I'm the Community Engagement Coordinator here at the city.
Awesome. And then, like I said, we have with us Chris Saunders, who knows a ton about MLUPA to help walk us through that particular law. So Chris, do you want to say hi real quick?
Sure. Pleased to be with everybody this afternoon. Look forward to getting some good questions after the presentation.
Awesome. So hopefully you guys have some yummy lunches at your desks and are ready to learn, and we will kick things off. Um, Actually, Emily, could you go back one? Thanks. So today we'll be chatting about some background on our Engage Framework Update project and sort of what led us here to this point, a little bit about MLUPA, and then we'll also be talking about the development review process and participation, how to give an effective public comment in light of MLUPA, and then end our session today with some Q&A. So if you have questions on MLUPA or our engagement processes, we're happy to answer any of those. All right, some background. In 2023, the state legislature passed MLUPA, and when they did that, they really overhauled land use and essentially set minimum requirements for public participation. So that they said, here's how we want you to do land use, and now that you're doing this, make sure that you do it in this way involving the public and set some minimum standards there. We're broadly doing what is called for under the law, but we still wanted to take this opportunity to draw that connect that direct line connecting MLUPA and our engagement framework. We're also taking this time to really look at our processes, reflect, and ensure that we are improving our engagement program to the best of our ability. Really just wanted to open it up to the public and ensure that they had a chance to, now that they've gone through this process for the past 5 years or so, make any changes that they want to see in the program, and also get a chance to really understand what MLUPA does to land use and public participation. So another big goal of ours in this process was not just to update our framework, but to really increase awareness about MLUPA and to also increase awareness about the ways to engage with the city and ensure that all of our residents had the opportunity to learn more about our Engage Bozeman platform and Engage Bozeman framework and understand how we do engagement at the city. So here is our engagement framework. The image on the right is a sort of screenshot of the front page of our framework. Many people, if you're really looped in on the process, you might have seen the engagement template that we provide for each individual project. This is not that. This is a larger strategy document that the city created and adopted by City Commission back in 2021. So the framework outlines the overall strategy for our engagement program. It doesn't go into individual projects. It's more staying high level and saying, here's the way that we want to do engagement at the city. So it has guiding principles on engagement. It talks about the IAP2 approach, which is the International Association of Public Participation. This is this sort of organization that a lot of governments follow when they do engagement. We also define what engagement is, as well as the decision-making timeline, so the points in which we typically solicit engagement, and then at what level we're soliciting engagement at and how it will be implemented. We also talk about when we do engagement and the situations where engagement occurs. as well as the tools and techniques that we use, and then the really important relationship between engagement and communications. So communications is that sort of one-way information out from the city, and engagement is really supposed to be a two-way process. So it's not just, hey, we're letting you know about this thing. It's we want to also hear back from you on what you think. And communications is a really critical piece of engagement because without knowing what's going on, you can't participate. So it's a critical sort of piece of the puzzle that fits together and works together. And we also have in our framework the community engagement life cycle. So um, the steps that we take throughout the process and what that process looks like, as well as some next steps for the organization and things that we are looking at as we implement. And now, would like to turn things over to Chris to talk about MLUPA.
Thanks, Takami. Appreciate that introduction. So the Montana Land Use Planning Act was adopted in 2023, and the city was required to complete our implementation process by May of 2026, which we did. For those who are not familiar with it, the Montana Land Use Planning Act for the city of Bozeman and a few other select communities in the state replaces all of our prior authority from the state to do land use planning, subdivision, and zoning. And by state law, we have to follow this law and not others in the work that we do. As a result of that, there's a number of changes in processes that we'll talk about in a minute, including public participation. And even though Bozeman is a charter community, meaning we have a little bit more latitude than some communities in the state, we are specifically required to stay within the sideboards for land use planning set by the state. One of those key elements, which is a continuation of the long-standing practice since at least 2003, is that land use plans and issue plans, so that's transportation, parks, the engagement framework, those kinds of things, those are policy making, they're not regulatory. We don't use them on individual applications, but they are the foundation upon which we build our zoning regulations and our subdivision regulations, which are the tools that we use for reviewing individual applications. One thing that is important for folks to realize is that many of the elements that MLUPA requires are existing practice for the city of Bozeman. Takami just gave you a little bit of a rundown on a general policy that we had adopted, the Engage Bozeman framework, that put a much more vigorous structure around public engagement for the city than the state law required. And it's very much in alignment with what MLUPA requires. So we were several years ahead of the state in bringing that forward, and other things similarly as well. Emily, next slide, please. So there are some specifics that I want to just touch on quickly. MLUPA is only applicable by law to about 10 communities in the state. There's some triggers for population of the county and the city itself that determine when MLUPA applies and when it doesn't. Other communities can choose to opt in and follow MLUPA, but there's 10 communities in the state that have to. As part of that, we need to, as a community, put a lot of effort to front load public input on development policy. So a lot of emphasis on engaging at the policy level, talking about things separate from the nuance of an individual application, and then later applying those policies after adoption. We specifically have to include some items to encourage the provision of housing. That's something that the state's given some strong direction on. Obviously, it's an issue that's been of significant concern for Bozeman for a long time. We also need to update some review processes. Some of these things were really significant changes for some communities, very similar to existing practice in some ways for Bozeman. Some things are fundamentally different. And then we also had to do some modifications for our advisory board. Community Development Board is the citizen appointed group who is the planning commission under the law. They offer recommendations for land use planning and policy making. And they also have a role that we'll talk about later in relating to appeals. So as we think about the items that we undertook to meet the requirements for housing support, the ones shown in green are the ones that we identified in the commission's action to adopt. Interestingly enough, H is the only one that wasn't already either an existing practice for the city of Bozeman or was not already required by other law. So part of the choice that we made in this was to have the impacts on direct standards be as light as we could. And there are other laws that exist that will continue to shape what we do with our housing options, but these are the 5 that we identified specifically to implement MLUPA. Next, please. So this is a general slide. It certainly is the flow that went through with the Unified Development Code update. But typically, when the city is working on things, we do outreach. Where appropriate, we do work sessions, either with advisory boards or with the city commission, to take that outreach, take professional input, refine that, and move forward into the development of policy or regulation. And then there's an opportunity for the public to weigh in and decide their thoughts on the specifics. This is something that was very effective in the Unified Development Code update. There were a number of substantive changes that came out of this cycle as the commission worked through different issues. People weighed in writing or speaking at the various meetings to identify their priorities. And so this was a very effective approach. We expect that this is kind of an ongoing practice that the city exercises. If you watch the commission agendas, you'll periodically see work sessions popping up on a whole range of different issues for all the different departments. Next, please. So as we think about implementing land use review, that is done in Article 7 of the Unified Development Code. That's Chapter 38 of the Municipal Code. And so the state sets some very broad guidelines and some very specific things too, but the city refines those and makes them Bozeman's through Article 7. So this is where we identify duties and responsibilities, what materials are submitted, how applications are received, how they're reviewed, how answers and decisions are provided. So this is the bulk of what we're going to be speaking about today. Next, please. Next, please, Emily. Oops, skipped one. There we go. Thank you. So I'd like to start on policy making. This is one of the significant changes from MLUPA, that there's a very strong emphasis at the state law level for a lot of public engagement and participation at the policy making level. And as part of that, they've identified this list of specific things that the city has to do in order for us to meet the requirements. And so we need to make it possible for people to get a hold of the information. We need to use electronic methods. That's a new thing. Previously, everything was, yes, you publish something in the paper. Yes, you have a printed document available at City Hall. And that was as far as the law went. Now we explicitly have to provide for dissemination and receipt of electronic information. So bringing some things into the modern world. This is a change that has generated a fair amount of conversation in the courts and in the state, and the Montana Supreme Court has recently weighed in and upheld the practices for public notice, for public participation that MLUPA calls for. So that has now been settled. When we talk about policy making, that's where we've got the most opportunity for people to weigh in, both by subject and frequency. When we move on to site review, then the noticing process changes, becomes more limited, as well as the opportunity for individual public comments. And we'll talk about that in just a minute. To start with, Emily, next slide, please. We'll talk about who are the participants in this process. So there's, first of all, the reviewers and recommenders. These are the folks that look at but don't necessarily decide the actions that are going to be taken. For all kinds of applications, city staff participates in that review. Depending on the scope of the review and the nature of it, different folks may participate, but it's not just the planning staff. Depending on the application types, it may involve engineering, parks department, fire department, water conservation, utilities, all kinds of different folks that have a responsibility for part of the area that's being affected. And we can also bring in outside agencies for this review. So if there's a need to connect with a state or federal agency, we're able to do that. The Community Development Board also has a recommending role when it comes to policy making. So things like new plans, amendments to the text or the map, zoning map, they have that role. And then once those reviews are conducted and the recommendations are made, it moves up to a variety of different decision makers. For policy making, that is explicitly limited and restricted to the city commission. So they adopt the plans, they set the code, they adopt the zoning map. They're the only ones who get to do that. When it comes to site development, so that's a subdivision, site plans, individual building permits, things like that, that is explicitly assigned by law to the planning administrator, who for the city of Bozeman is the director of community development. And so the recommendations from the boards and from the staff go to the city commission or the planning administrator as appropriate, and a decision gets made. If there's an appeal, then the decision maker, it's actually a two-step process. Folks can appeal to the Community Development Board. Depending on the decision by the board, that may be the end of the process. If folks wish, they can appeal the decision of the board up to the city commission and from there to the courts. So that's a change. It used to be the direct step from planning to the city commission, but there's now an extra step in there. As we go through, we'll talk about how the individual types of applications have opportunities for public comment, but for all of them, the basis of the decision that gets made and the findings that support it are provided through the code. And so that's state law, that's municipal code, and then all of those decisions are made in writing so that there's no question about what it was. Some changes have occurred in this process that folks may need to know. One is that there's no longer an option for the city commission to reclaim review. For a long time, there was an opportunity for the city commission to reach down and pick up the responsibility for something that was to be reviewed and approved by the staff. That's no longer there, and now has to stay a decision at the planning administrator level, and then it can be appealed and work its way up. For site development, again, if it's legislative, then it goes directly to the city commission, no matter what, because they're the ones who have that responsibility. So next, please. So one thing that's also a significant change, there's a new term in the law called substantial compliance. And it is the fundamental basis of any decision, whether a project is substantially compliant. As part of that process, the state law is explicit that an application does not move forward to noticing until somebody has made a determination that the application is substantially compliant. We'll touch on more details in a moment. The reason I'm bringing this up is there have been folks over the years who have expressed some concern about notices not going out until an application has addressed concerns. And we certainly are aware of that. However, in this case, the state law is now explicit that the decision maker needs to make that determination of substantial compliance. That's the basis of the notice, and then folks get to weigh in on whether or not they agree with that determination. So that is going to have some effect on timing, both of when things like staff reports are made available to the public and also when the comment process kicks off. Emily, next, please. So there are three large classes of review in MLUPA. The term ministerial is explicitly defined. Legislative and non-ministerial are not, but we had to call them something. So that's the term we chose. A ministerial review is a very simple, direct, objective review criteria kind of review. They don't get notice at all. Non-ministerial can be more specific, complex type reviews, things like subdivisions or site plans. They do have a review option for public comment. And then the non-ministerial legislative, that's making the policies again. That is where most of the emphasis on the notice participation is placed. If you're interested in what kinds of reviews fit into these classifications, section 38.730.020, table 1, lines out each of these different classes and what kinds of applications fit into each type of review. Next, please. So just a little bit of additional background for any of these review types. This is section 3 of article 2 of the Montana Constitution. Montana Constitution identifies many different rights and responsibilities that are held by the public. And a lot of times there's some conflict or competition between how folks see particular rights on either side of the property line or somewhere else. And so zoning is one of those tools that exists where through the public process, there can be an effort to find the balance between the rights and the responsibilities that exist. And so everybody knows what the rules are, and we're not redebating that every single time somebody wants to move ahead. I'm mentioning this because most of that process happens during that legislative policy making process. When we set a setback, when we set a building height, when we set all kinds of standards, that happens through that legislative process. So City Commission with this and other things has some latitude for setting the policy they wish to make, but they also have a lot of restrictions on what that policy can be. So let's talk about the legislative process flow on the next slide, please. So this is pretty similar to what the past practice has been. Some of the changes that occur are the criteria for approval are different in the state law. For those who've been watching land use for a long time in the city, you'll remember seeing the staff standing in front of the commission, putting slides up saying, here's the criteria for your decision. And there's A through K. And those are all different now. And so the criteria we use are different. It's now always a simple majority who makes the decision. There's not a protest option that requires a simple majority anymore. That came out of the law even before MLUPA. So that's something. And then one other related element is that the city cannot attach conditions to things like zone map amendments. And so if the policy is going to be made, the policy is going to be made. So as we start looking at this flow, when somebody submits an application, each of the dashed lines that you see are an opportunity where there may be a requirement for information to be added to. So somebody is doing the work. They're reviewing an application from inside the city and they identify that there's something missing. So that will route back to the beginning. Things get submitted again as needed. It gets back through the individual steps and then it proceeds forward. The first green box there says determination of substantial compliance. That's by the staff. If we believe it is substantially compliant with the law, then it moves forward into the staff report and notice phase, moves on to the Planning Commission, who holds a public hearing. The Planning Commission then also has to make a determination of substantial compliance prior to their recommendation to the City Commission. So there's a lot of work that happens before it goes out to the public and before it moves on to the City Commission for their action. Now, the City Commission is not bound by the recommendations of the staff nor the recommendations of the Planning Commission. So they can make the policy decision that they feel they need to make in the best interests of the community. And I think that's that for this one. So let's move on. So as we're looking, when the commission or the board or the staff is looking at making a decision for some legislative policy, the state gives some specific language that we're supposed to look at. This is kind of the thumbnail sketch, if you will, of all of the criteria. And it says that the proposed map regulation or amendment taken together comply substantially with, and then it identifies a series of things that we have to evaluate. And what it's really looking back to is the adopted land use plan and issue plans. So where is the community thinking about development? What kind of utility planning have we done? Lots of different elements all look at that are all brought into that conversation and part of the evaluation. So hopefully that makes sense. It's the same concept of substantial compliance carries through for legislative decisions and site-specific decisions. So as we're looking at this review process, Emily, if you jump to the next slide, please. There are some things that have to happen, and the city's taking care of these. So we have to have adopted a planning commission. We have to have a public engagement plan. We have to have a land use plan that we're regulating against. And so all of those things have been completed. The city adopted land use plan back in October of 25. And so all of these steps are taken care of. So they are important and essential in the process, but they don't come up every single time. Next, please. When we look at noticing for policymaking processes, we do have to follow some of that element from state law in section 106. Takami touched on that. Part of the way we've satisfied that locally is through the adoption of Chapter 38, Division 730, which describes the contents of the notice, when notices go out, where they are placed. In the case of legislative actions, those specifically require a public hearing. And so there's the public hearing before the Planning Commission and the City Commission. So there's a more robust process. And then those are kind of the minimum floors, depending on the scope of the work. Like with the UDC update, I believe there was well over 100 separate public engagements that were part and parcel of that. And so we can take it as far as is needed for the scope of the work being done. Next, please. So one of the things that changed with the law, and this is a local choice, the city has for a long time had a requirement that there be a mailed notice to property owners within 200 feet of any zone map amendment, and that's measured from the outside edge of the property to a measured distance. We do take into account things like streets or streams or other things in doing that measurement. And the commission chose to expand that to 300 feet to reflect that priority in the law about greater engagement at the policy making stage. So that's a local preference. There is no requirement that there be that kind of a mailed notice in the law. but the law does allow us to have that kind of additional notice provided. Next, please. So looking at ministerial, I mentioned earlier, there is not a notice process for ministerial applications. So you'll see that there's nothing that says notice in this flow. Many of the other steps are the same. The substantial compliance determination still has to be made for each application. So this is the simpler of the processes and probably the majority of the applications that the city reviews. Next, please. So one of the changes that happened with MLUPA was bringing a lot more parallel construction for how zoning and subdivision review processes work. So now used to be that there was a three-step process in subdivision. Now there's basically the same three-step process for zoning as well. The concept or pre-application review is an opportunity to check in, identify significant areas of concern that need to be addressed during the formal application so that there's not delays. And then also if there is information where an applicant believes that some of the information we might require is irrelevant, then they can ask to be waived from that and the staff can evaluate that request. The plan review and preliminary plat stages are the places where we do the public notice. There is no public notice of any kind at the concept or pre-application or the final plan or final plat, although the final plat does appear on city commission agendas. Both plans and plats are approved by the community development director. Next, please. So the flow for this, as you'll notice, looks an awful lot like the same flow as legislative, the difference being that there is not a hearing. If there is notice that is required to be issued, that is a written notice opportunity. And so the notices do go out according to 38-730. And then there's a 15-day public notice period. That time frame is specified in statute as the minimum business days. And then the city will review the comments. If there is a identification in the comments of missing information, then we will make a determination that the application is not substantially compliant, and we will put that project on hold until the applicant can provide the missing information. If it is compliant, then it moves forward for a director decision. Next, please. So when we're doing site development notices, you'll notice that they are similar but different. The notice period is the same. The method of notice, depending on what it is, may or may not include mailings. We did explicitly add in notice to certain water-related interest folks, things like ditches and irrigation that are affected. So that is an element. We also had to coordinate with floodplain and agencies. And so that also shapes some of the notice that gets put into place. But generally the notice is a little bit less robust than it used to be. It's still there, it's still on site, but it is there. One thing I would call to people's attention, we don't know where this is going to land yet for sure at this stage, but the law as currently written has some differences that would further restrict the notice process that would kick in on July 1st of 2027. We'll see if the legislature modifies that in the upcoming session in the beginning of 2027. But just wanted folks to know that we anticipate that there will be some changes here in the next year. Next, please. So the last process flow is appeals. Appeals can be of any administrative decision, and so those have to be turned in within 15 business days of the date of the decision. Unlike a standard application, there are some specific limitations in the law about what can be appealed and how that appeal works. The appellant has the burden of proof in support of the appeal, and it has to be specifically tied to a lack of compliance with the law. So an appeal that says, I don't like this policy, it's not the way I would have done it, those are not a basis for a site-specific appeal. It has to be direct lack of compliance with the law. So a little different here. If you look there in the second row, you'll see that there's a two-part Community Development Board / City Commission button. That's because an appeal from the staff first goes to the Community Development Board, who makes a decision. Then there is an opportunity for a second appeal from the Community Development Board to the City Commission. It follows the same flow that you would see here. It is a separate application because the content and substance of the appeal may be very different between those two events. So it's a little different than what it was in the past. So all of these opportunities for public comment all carry certain requirements that need to be met. And so that's where we're going to move into now and talk about effective public comment. So next, please, Emily. So when somebody's looking at an approval, whether that's the planning director or whether that's the Community Development Board or the City Commission on appeal, they're all looking at this same language, that it complies with the standards set in the applicable regulations. So that's the pieces and parts that we have to focus on. So if there is a concern that folks have, we need to make sure that any public comment focuses on this kind of language. What is the specific criteria? What is the specific standard? What are the points of concern? So next slide, please, Emily. So for effective public comment, the comment in the event of most applications will be written only. But for any of them, whether you're speaking at a public hearing or whether you're sending in writing, these all apply. You can be able to identify specific criteria of concern in the regulation. It's section number X. You can identify specific elements that you as the speaker or writer of the comments believe do or do not comply. And then you can submit facts in support of that. Like I said before, if it's just, I would do it differently, that's not non-compliance. If it's the setback says 5 feet and the building's at 4 feet, and here's the drawing that shows that in their submittal, that's something that's actionable, and we can certainly take steps. So that kind of direct connection between here's the code, here's what is or isn't in compliance, and this is why. Those are the kinds of things we need to see for comments to be the most effective. Flipping that on its head, things that are ineffective public comment are statements that are not tied to the code, but I don't like it. Okay, we totally hear you. We give you full credit for the concern that you have, but that's not something that we can really weigh on the basis of a decision. If there's not specific elements, I don't think it's the right building for that site, for example. Okay, why? We don't see a why. There's no supporting information provided there. Or if it's raising issues that are outside the scope of the review. The application itself for an individual application has a very limited set of material that applies to it. If there's a desire to reconsider a policy, that's fine. Folks can certainly advocate to the commission to modify a policy, but that's separate from the review of an individual application. So just some cautions there. One other thing I'd just like to touch on, certainly, I think anybody who's been watching the news in the last several years has heard lots of talk about artificial intelligence. I would just offer a caution for anybody who's using that tool, informing your comments. The nature of AI tends to be that it looks very broadly. It looks at information that may or may not be relevant to the specific site or the specific standard that you're concerned with. So a comment that the application that you are concerned with doesn't comply with a standard that's applicable in Rhode Island is not going to be helpful. So we certainly can learn from other communities, but just be careful about checking the material that you're getting to make sure that it's pointing to the right sources and the right relevant information so that your comment can have the weight that you would like it to have. And last slide, on to questions.
All right. So I'll be kicking off the Q&A session. I'll mostly be going off the order that we received questions in, unless I'm seeing some common themes. So we'll start with our first question. Does the city already have most, if not all, of the issue plans established and on a schedule that gets reviewed regularly? I'll toss that over to Chris.
Yes. There's about 24 of them. If you look in the land use plan, there's actually a list of them presented. Some of them have very specific timeframes. Others are evaluated periodically. There is not a hard and fast, it must exactly happen this fast. The only one where there's a hard and fast rule like that, to my knowledge, is the land use plan itself. But the city does update plans every single year. We have the forestry plan and the integrated water resources plan underway right now. So there is always some of that work happening.
Thanks. Next question. You mentioned that Bozeman was already doing all of the options that were selected from MLUPA. This is referencing the housing option slide. Were the changes in the UDC to how things were zoned and how zones, density, et cetera, were defined mostly policy choices then?
Some of them, like item H, that was removing lot size, that was specifically something that we did differently for the purpose of complying with MLUPA. Some of them were side effects of things. When, for example, the state in 2023 passed a law that said you had to allow a duplex in every district where you could allow a single home, it made some of the districts basically not really distinguished from each other, so it made more sense to bring them together. So there were some things that were directly from the law, some things that were implied from the law, and then some things were local choices.
Thanks. All right, this question's from Eric. He says, as for policy input, Chris mentioned many city entities, e.g. the Community Planning Board, from which input is sought and welcomed. Do private for-profit businesses, such as developers, realtors, already have seats within these endorsed entities? Otherwise, through which channels can uncity affiliated entities or private citizens give policy input? Chris, I'll let you share your thoughts, and if I have anything to add, I will.
Sure. Let me start at the high level first. Number one, you get to vote. And so that's kind of the ultimate board for the city is the city commission, and everybody gets to vote for the people they choose to. Stepping down from that, the city currently has, I believe it's a total of 12 advisory boards, including the community development board. And those folks are appointed by the city commission, and they're assigned specific duties. They hold public meetings, and they can receive written comments, or you can come speak in person directly to them. So that's certainly an option for anybody at any point in time. To the best of my knowledge, there isn't a placeholder, if you will, for like the realtors group or the developers group or something on any of those boards. On the community development board, there is in the language that creates the board that says they need to have some understanding of the development process. That could be a lot of different things. And that's so that they can be effective in the work that they do. Um, so that's, something to watch for. But part of the reason that we do the very aggressive public engagement, like we did with UDC, with a great number of events, surveys, all kinds of different ways of reaching out to people, was to encourage the broadest possible participation. So we definitely want participation from any members of the public who choose to participate. We also encourage folks to spend some time on some research so that they can participate effectively. Oftentimes, one of the things that we hear folks express some frustration about is, but I gave them my public comment and they didn't follow it. Certainly understand why that would be frustrating. Sometimes we don't follow it because the law says we can't. Things like rent control, cities just simply can't do that. It's outside our legal authority in Montana. Other states obviously do it differently. So sometimes we just can't do what people ask, and sometimes we just have competing priorities. Sometimes we can find a middle ground, and sometimes we can't.
Yeah, I think the only other thing that I was thinking about in this question was just that um, we have this conversation was really focused on land use and all the processes under that particular topic. But we do have engagement that falls outside of land use and use our Engage Bozeman platform to gather input from the public and share that with the commission. And there's on occasion things that they have work sessions on or talk about or decide that don't really go to a board and don't really fit. So there are one-off things too that happen outside of all of this.
Mm-hmm. Yep.
Um,
To touch on a couple other things for follow up on that. The Engage Bozeman website is an amazing tool. If you're interested in participating, it's the best way to keep up with the very many processes that are happening at any given point in time. The other process you might want to look at is the City Commission does publish a calendar of major events that are major subjects that they're talking about in the next 6 months, and it gets updated about every other week or so. So if you go on the city's website under departments and City Commission and then calendars, it's just a PDF. You can pull it open and take a look, and it changes, of course, over time. Don't always hold to the schedule that we'd like to sometimes. But if you're wondering what the City Commission is going to be looking at in the future, that's a great way to find out well in advance.
Thanks, Chris. All right. Next question is from the Sentinel. Will the city be still sending out the weekly email with projects under review? And will all the projects that are under review still be included in that email since noticing requirements are changing?
Excellent question. For now, yes. We're going to have to wait and see a little bit about what comes out of the final decisions from the legislature in 27. There is a distinction between sharing information of we have an application, which is simply sharing information, or soliciting specific comments on a specific application. And so that's something we're looking at and figuring out how best to handle that. But for now, we are intending to continue the weekly distribution.
Thanks. That actually kind of leads me nicely into the next question, which is high level. Can you describe some of the noticing changes that are on the state's radar in 2027?
Sure. If you want to look at the information yourself directly, you can go onto the state's website. It's included under the law. So in Title 76, Chapter 25, and Sections 304 and 408 are the two for zoning and subdivision. It says what will happen effective July 1st of 27 if nothing else is changed. And essentially what it changes from is the current standard that after determination of substantial compliance, a notice is issued, and then we take the public comment, to a situation of we determine it's of substantial compliance and that there is not substantially different impacts. So a second level of determination getting made. If there are not substantial impacts, then there is no notice at all. So it's a pretty significant shift.
Thanks, Chris. Actually want to jump down to a question that just popped in. And hopefully I understand your question here, but Sarah was asking where do we sign up for that email? I think you might be talking about e-notifications to get notified about city commission meetings and to see what's on their agenda. So if you can do that at bozeman@mt.gov, or if you are, so that's one thing that we do, and make sure you check your spam folders if you're not seeing emails pop up from us. And then another thing that Emily does is she sends out a monthly engagement digest on all of our engagement projects. So if you're signed up for any project on Engage Bozeman, you should be getting that digest too, and be sure to check your email if you're not seeing that. Next question. Does this effectively reduce the workload of the city commission? So the changes in MLUPA, does that impact the workload of the city commission?
A little bit. One of the things we did in evaluating this is we looked at a 3-year history of applications, and we looked at what the commission needed to do before and after MLUPA, and it made about a 2% difference in the number of applications that went to the commission. About 94% of the applications were being handled by staff originally. So it hasn't made a huge difference. Things like zone map amendments, annexations, any kind of text change in the regulations, all of those must continue to go to commission, and they were going to commission previously. So that might be very different in some other communities, but for Bozeman, at least as a percentage of total work, it hasn't been a huge difference.
Thanks, Chris. Next question is also for you. Have members of the community development staff reviewed the changes to the city charter being made as part of the local government study process to ensure that the language being used does not conflict with MLUPA?
I have not seen that language yet, so no. I can't speak to anybody else, but for me, I haven't seen it yet.
Yeah, thanks, Chris. Do you see MLUPA as a positive or negative to a more efficient or timely development review process?
I think on balance, it's positive because it puts more emphasis on following the rules as adopted. And I've been doing this for 30 years for the city. And when the regulations are unclear, that generates frustration for the applicants, for the members of the public, and for the staff. So the shift in priority under MLUPA provided a strong motivation for the city to look very, very carefully at the language and try to make sure it was as clear as we could make it when we did the latest update. Now that's not a new thing. we try to avoid things that are uncertain and confusing at all times. Sometimes that works better than others. But we did clear some things up during that process that had been not as clear as we would have liked, and it'll be something that we continue to monitor.
Thanks. I'm going to jump to Rob's question. Where would private citizens that don't fully understand the process and broader land planning policies do further research to better participate in meaningful engagement? Chris, I've got some additional thoughts on this, but wanted to see if you had some first.
Sure. The starting place is always the land use plan. And so that's available through the community development website. And there's also information in there that ties to the other documents that are involved, like the transportation plan and sensitive lands plan and others. So those plans are the basis that support whatever regulation gets adopted. The complicated part of this is that Bozeman doesn't get to do what we want all the time. There's a lot of limitations, not just directly from the legislature, but from the state and federal constitutions and all kinds of laws and legal rulings. And so a lot of times we're trying very hard to thread a pretty fine needle in setting policy that's responsive to local wishes and also conforming with the law. And that's something that, you know, unless you do this full time for a few centuries, you're probably always running on catch up. But starting with the land use plan is the first place, and then the code itself. We also, if you bump into a question, we have what's called a planner of the day. So that's an on-call member of the professional staff. You can call in or send an email, and we can try and help answer some questions. So those are all starting points.
Yeah, the other thought I had too was a program we haven't fully launched yet, but we're just working on in the background is a Citizens Academy for the city. Excuse me. And uh, many residents, oh no, I'm so sorry about this. I can't figure out how to turn this off. But many residents might be familiar with our citizens academies in fire and police. And we're trying to do something similar for the city broadly as well. And definitely want to have a night devoted to land use planning and making sure that residents understand how the city does it and how they can participate. So that's another thing we're exploring. And then also want to try and take some of the material that we've had in this presentation to share out on social media too, to help further just increase awareness about the law and what people can do to be effective as they comment on land use. And then Chris, this wasn't really a question, this last one, but if there's anything else that you wanted to add, Eric just had a comment that it sounds like the city planners have a clear sail to avoid any protest against any specific land use plans. Yeah, just tossing that over to you.
Well, let me be careful about the answer there. The term protest in the law is a very specific thing. And it generally means that if there's a sufficient protest, then some process stops. And even under the prior law, a protest against a zone map amendment or a text amendment would not stop an application. It would require a supermajority of the commission to approve it, but it would not stop the application from going forward. There has not been a protest for a land use plan in the past. So to that degree, yeah, there isn't a protest. There is certainly an option for members of the public, and we certainly encourage them to engage and share their thoughts and concerns. But the clear direction under MLUPA and other state land use laws before was if the landowner is following the rules, then they're going to get an approval. If they're not following the rules, then it will be turned down. Will not get approval. So it's not as much of a difference as it might appear to be. Hope that answers the question.
Thanks, Chris. We are now at time, and thank you so much for everyone for participating. I know it's a lot to just kind of give up an hour during lunchtime to talk about land use and engagement at the city. And we really appreciate that you guys are so invested and really care about these topics. And it's been really helpful to get everyone's feedback so far and hear everyone's questions. So thank you so much for being informed. And if you have anything else, any other questions, don't hesitate to reach out to any of us. More information on our contact and how to reach out is on our website. So feel free to reach out, and thanks everyone for coming.
Thank you, everyone.